Be ready for dictation. 5 seconds. Start. As demonstrated above, subsection 2 of section 52A specifies the procedure as contemplated in subsection 1 thereof for the disposal of the seized contraband or controlled narcotic drugs and psychotropic substances. Any deviation or delay in making the application under section 2 by the concerned officer to the magistrate or the delay on the part of the magistrate in deciding such application could at the most be termed as an irregularity and not an illegality, which would nullify or vitiate the entire case of the prosecution. The jurisprudence as developed by the courts so far makes clear distinction between an irregular proceeding and an illegal proceeding. While an irregularity can be remedied, an illegality cannot be. An irregularity may be overlooked or corrected without affecting the outcome, whereas an illegality may be lead to nullification of the proceedings. Any breach of procedure of rule or regulation which may indicate a lapse in procedure may be considered as an irregularity and would not affect the outcome of legal proceedings, but it cannot be termed as an illegality leading to the nullification of the proceedings. Section 52A was inserted only for the purpose of early disposal of the seized contraband drugs and substances, considering the hazardous nature, vulnerability to theft, constraint of proper storage space, etc. Cannot be any two opinions on the issue about the early disposal of the contraband drugs and substances, more particularly when it was inserted the implement to provisions of International Convention on the Narcotics, Drugs and Psychotropic Substances. However, delayed compliance or non-compliance of the said provision by the concerned 23 officer authorized to make application to the magistrate could never be treated as an illegality which would entitle the accused to be released on bail or claim acquittal in the trial. When sufficient material is collected by the investigating officer to establish that the search and seizure of the contraband substances was made in due compliance of the mandatory provisions of the Act. The Apex Court further considered the scope of Section 52A in light of the decision of Constitution Bench in case of Puran Mal versus Director of Inspection (Investigation) New Delhi and others (1974) 1 SCC 345 and Constitution Bench decision in case of State of Punjab versus Baldev Singh (1999) 6 SCC 172 as well as decision in case of State of Himachal Pradesh versus Prithvi Chand and another (1996) 2 SCC 37 and State of Punjab versus Makhan Chand (2004) 3 SCC 453 and held the evidence collected during the course of investigation in legal and proper manner and sought to be used in course of trial with regard to the seized contraband substances could not be simply brushed aside on the ground of procedural irregularity if any committed by the contraband concerned officer authorized in making application to the magistrate as contemplated under section 52A of the Act. Relevant paras 31, 32 and 33 of the judgment in case of Kasif within bracket supra are extracted here as under. From the above decisions, the position that emerges is that this court in catena of decisions has approved the procedure of spot searches and seizures in compliance with the standing orders and the notifications issued by the NCB and the central government and upheld the convictions on being satisfied about the search and seizure made by the officers as per the provisions of the Act and being satisfied about the scientific evidence of FSL report, etc. Over.